Okay, so when comparing and contrasting civil liberties to civil rights, right? Again, we talked about 3 ways to contrast them. Starting with what kind of right are we talking about when we talk about civil liberties?
It's God-given.
Yeah, those God-given natural rights. What kind of rights are we talking about with civil rights? Kelly?
There are issues for citizenship.
Yeah, your citizenship rights. When we talk about who the rights kind of uniquely apply to, you know, if I have a case and it's a civil liberties case and I win, whom am I winning increased kind of, you know, protections for contrasted to a civil rights case?
With civil liberties, you're protecting them for everybody,
Yeah.
and with civil rights, you're just minorities.
It's unique to minorities, perhaps. So what I want you to see is if it's a natural God-given right and I get an expanded definition of that, it has a universal kind of benefit to all. For civil rights, I'm trying to win a particular group their citizenship rights that they've been denied because of their demographics, right? So again, you could talk about, well, now I have this guarantee of a right and it should apply to everyone, but there's been a particular group denied it based on race, based on gender, based on age. There's a number of reasons why they might be discriminated against. For that reason, when you think about the solution, right, what do I need to have expanded civil liberties? Less government. So we consider that a freedom from, a negative freedom. Contrasting, you know, what do I need for civil rights?
More government.
More government. I need government to do something proactive. I need them to go in and tell an institution or a state that this particular practice is not just, and here are the consequences if you don't fix your practicing, right? Or practices. From there, we began to look at the process of applying the, you know, now that we've defined it up and we know we're going to look at civil liberties, we're going to look at the process of applying those liberties, and specifically the Bill of Rights, to the states. And initially, our position was what? Do you guys remember? There's 3 different kind of, I got to give you the word. 3 different kinds of incorporation. Where were we initially? Did the Bill of Rights apply? Where were we initially? Go ahead, Nick. No incorporation. Where will we get to eventually? Where are we today? Selective. What did we not get to? Total, right? So that process starts with Barron versus Baltimore. Now, real quickly, what was the controversy over? Liam.
Barron's property was damaged
Yeah.
by a city construction project.
Good.
They wanted compensation.
He wants compensation under the Fifth Amendment's guarantee to, Kelly, eminent domain. When Marshall looks at this case, does he apply the Fifth Amendment's guarantee to eminent domain? No. What does he look at to decide that that amendment doesn't apply?
The first one.
The First Amendment, which says Congress shall make no law. And therefore, the Bill of Rights must be unique to Congress. And therefore, Fifth Amendment doesn't apply to the states. Therefore, no incorporation. The 14th Amendment becomes the wedge because it has specific language that must obligate the states to you know, adhere to the Bill of Rights. Chief among it is no state shall, right? But you guys know the Holy Trinity. No state shall what? What can't they interfere with? What are my 3? Everyone should be, and if you can't do this again, remember, this is instrumental to civil rights. This is instrumental to the expansion of federal power. This is instrumental to you understanding civil liberties. What's 1?
Due process.
Due process. They can't interfere with your due process. Liam?
Privileges.
Privileges and immunities, and Nick, equal protection. All right. So when I look at privileges and immunities, there is an argument that says, by definition, that phrase must make the Bill of Rights apply to the states. Why? In order for you to define privileges and immunities, what do you have to do?
Don't you have to go to is it Article 4 that says that like every state you have like the same privileges.
So you're thinking the full faith and credit clause and things like that. But what you did is you went into the Constitution. You went into the document, right? In order for you to understand what is meant by privileges and immunities, you went in and looked at that full faith and credit clause. You looked at privileges and immunities within the 4th Amendment. And similarly, you'd look at the first and second and third, and you look at all of those things in combination and say, this is what people are entitled to. Does anybody remember why the court said no? It says, no state shall interfere with your privileges and immunities of being a citizen of the United States. So they're going to just define your privileges and immunities as to what's in the Constitution based on your citizenship rights. And it's very limited throughout the document. All right? Similarly, I could use due process. Why? Why should I be able to use, how do you define due process? If I say you're entitled to certain due process, what do I mean by that? Yeah, if you're accused of something, you have certain legal procedural guarantees. There's a whole step of things that we have to go through. So logically, where would you go to find those legal procedural guarantees? Brian, where would you go? Yeah, and specifically the amendments, and specifically numbers. Yeah. So you look at the specific delegated powers of Congress, and you'd find some prohibited ones. They're like habeas corpus, no bills of attainder, right? How about the fourth? How about the fifth? I take the fifth. How about the sixth, right? Those are where all your rights of the accused are. Again, they're going to say no because we're only bound by the dictates of due process as contained within the 14th. When I look for the definition, I'm only going to find it in the 14th. I'm not going to jump outside the document. So they jump out when they want to, and they don't jump out when they don't want to, right? And so for a while, the 14th Amendment is not going to be the lever that we want until we get to Gitlow. And I found out I have to find a montage for you guys on James Brown because he's not as iconic as I thought, but he barks things. And Gitlow might be one thing he says. He's kind of a soul singer. You got to come up with the mnemonics. Could you remember these? Or was it, yeah, and we're only at like 3. There's going to be like 1,500. So Gitlow, who's Gitlow? What's he doing? What's he doing there?
He's a socialist.
Dirty socialist.
Distributing like papers to
Handing out pamphlets. Here's 1,600 pamphlets, right? That leads to revolution. That leads to anarchy. He's arrested under the New York Anarchy Act. What we have to decide again is twofold. Does the Bill of Rights apply to the states via the 14th Amendment? Or in particular, does the Bill of Rights, does the First Amendment guarantee to free speech apply to the states via the 14th Amendment? And if so, does this constitute a violation of speech? So step 1, yes, we apply the Bill of Rights to the states via the 14th, or excuse me, I keep doing this wrong. We apply the First Amendment guarantee to free speech to the states via the 14th Amendment. We consider it one of your privileges and immunities. We consider it instrumental to understanding your due process rights, right? Why? If you don't remember, it's simply because. Do you remember? They just said it stands to reason it does. So they didn't give you a lot of logical reason. Did they then say that this constitutes free speech? And if so, why? And if not, why? What do you think, Kelly?
Because there's a clear and present danger.
They said no, that this is not free speech because it constitutes a clear and present danger. What was troubling about that? It's 1,600 pamphlets.
There's a chance that it could cause some
Good.
mass anarchy, but it's not likely.
It's not likely. So later on, we've got to come up with the probability of it. We've got to come up with the standard that is the speech has to lead to. I always think this is a great band name. If you're going to form a musical band, you want to call it this. As Nick's guitar lessons take off, right? What are you going to call your band? The speech has to lead to, what is it, Nick?
Imminent danger.
Close. Imminent lawless action. And I would go see that band. Imminent lawless action. That comes up later, okay? So this is, by the way, to make it more confusing, Gitlow versus New York is where we apply the standard that we came up with in Schenck versus U.S. Anybody remember in history classes studying Schenck? Same kind of case. But that was where, on a federal level, we said that we can prohibit speech that leads to a clear and present danger. And now we're applying the Schenck standard to the states in Gitlow. So come up with a mnemonic that puts all that together. Question? Or
Oh, I thought you were asking.
you remember Schenck. We're going to cover it a little later, but what is it again?
It was when they were distributing like pamphlets
Pamphlets
to
again.
avoid the draft.
Yeah, it's a pamphleteer who's a socialist who doesn't want people to sign up for the draft. Okay, so that's Gitlow. Near versus Minnesota. kind of case am I looking at? I got speech. This is press. This is a muckraking tabloid that is critical of certain elected officials. What they do is they put a perpetual gag order on this paper, right? And so again, what we have to look at, does the First Amendment guarantee to freedom of the press apply to the states via the 14th Amendment? And if so, does this constitute a violation of the press? Okay, yes, we're going to apply the freedom of the press to the states. What do we think about this perpetual gag order? What's wrong with it? Go ahead, Kelly. It does violate. What's troubling about putting a gag order on a newspaper perpetually? Is there a better remedy if a paper kind of crosses the line? You have to think about why it would cross the line, right? If it defamed somebody, if it sullied your name falsely, slander, libel, if it put troops in harm's way, if it published something obscene, do we have a better remedy than stopping them before they print? There's your hint. Yeah, it's called subsequent punishment. So there are two tools, prior restraint and subsequent punishment. The one that we favor is subsequent punishment. Why? Why is it so important to have a free press? Jenny, why is it so important? What are we? We're a democracy. Why is it so important we have a free press? You gotta. This is the way that we know what our government is doing, so we make an informed decision. It is sacrosanct that we have a free press. It is a cardinal kind of rule that we have a free press. Otherwise, it's not really a democracy. So we're going to rely on that subsequent punishment. Now, we get to Powell versus Alabama. Somewhere. There we go. And you guys remembered it more by the familiar. What was the name of the African-American boys that were put on trial? Scottsboro boys, right? Because of the kind of location of the case. So what you have here is a case where 9 African-American boys we're in 1932. Post-Depression kind of coming out of it. Rail hopping is still kind of a common practice and pastime. A youth of African-American, a group of African-American youths get in an altercation with some white kids. The white kids are essentially thrown off the train. They then report the African-American boys to officials. And by the time all is said and done, not only are they charged with assault, but they're charged with assault and rape of 2 white women. And that certainly is, in this time, quite a taboo. Consequently, it's, they're going to proceed with kind of the haste of a lynching mob because what this case is wrapped up in is race and that idea of rape of white women. All right? So what we're going to look at here, though, is the right to counsel initially. This case takes on kind of Shakespearean quality in its twists and turns and kind of tragic features because we'll have multiple kind of retrials. But in the initial trial, we're going to look at the idea of the right to counsel. And does it apply to the states via the 14th Amendment? And if it does, were the boys denied an adequate right to counsel? Okay, again, 2-step issue. The problem is they were given a right to counsel, but a hasty one. No one in the county wanted to volunteer to be their defense attorney. Eventually, they kind of dug one up, and he was given last-minute kind of rights to go see them. He conferred with each of the clients for like 25 minutes, moments before the trial. And to make it worse, he's an aging alcoholic kind of guy. His name is Stephen Roddy, and he's a known alcoholic. All right? So does that sound like adequate counsel? Is that a right? You had an attorney, but you were given a brief amount of time with him. He was perhaps reluctant in the first place, and the only reason you got him is perhaps because he's an alcoholic. How good is he going to be in terms of representing you? So again, we're going to look at does the right to counsel as guaranteed by the 6th Amendment apply to the states? And if so, was there a violation of the right to counsel based on who you were given? The court rules that yes, it applies. And then the court, in its logic, I like the quote, says that the right to counsel is of such character that it cannot be denied without violating those fundamental principles of liberty and justice which lie at the base of all of our civil and political institutions. It's fundamental. You cannot, if you deny the right to attorney, you have compromised every other guarantee that you have in terms of your legal procedural guarantees. It also overturns the guilty verdict. And its logic is this, and again, I like the quote, that a defendant charged with a serious crime must not be stripped of his right to have sufficient time. Right to counsel includes this idea of sufficient time so that you can prepare a defense. If you don't, to do so, to not give you sufficient time, is to proceed promptly in the calm spirit, to do that is not to proceed promptly in the calm spirit of regulated justice. That Tsarnaev trial, I don't know if you're following it, but just the jury selection alone was months on end, let alone the painstaking looking at evidence. And this, Tsarnaev is not, basically what they're trying to do in terms of defense is just say that he was under the sway of his older brother. He's not necessarily contesting his guilt. He's just trying to talk about his degree of guilt. Yet, we're going to have multiple phases of this trial. It's going to go on for quite some time because we want to get justice right. We want to make sure that we are proceeding promptly in the calm spirit of regulated justice and not going forward with the haste of a mob.
Doesn't he want to die, though?
Probably, I haven't... he's obviously not in a right mind mentally. His defense is making some inroads and trying to make him seem, I don't know, a little more human and a little more under the sway of the brother. Yeah, the whole attack in the first place had the idea of, a suicide attack. So I've heard things similar that, as to how accurate they are, I don't know, but that he doesn't want to do much in his own defense. And for that reason, a lot of people just want to make sure that it's, polls have showed that people want, at least in Massachusetts, more of a life sentence than the death penalty. I think that they find that more punitive, perhaps. At any rate, okay, so the Powell trial ends, and what we have is the right to an attorney being applied to the states and the verdict being overturned. Story over, right? No, we're going to try them again. Is that troubling? What does that sound like it violates? If I'm going to bring the verdict was overturned. What does it sound like it violates? Double jeopardy. But what you got to keep in mind is the verdict was overturned, but they were not acquitted. That's two separate things. What they did is they set aside the verdict. They said that this verdict was arrived at inappropriately. It is up to a district attorney to decide whether to refile charges, and they did. So technically, this is not a case of double jeopardy. If the Supreme Court had said, and we find him innocent, then it would be. But they didn't do that. They simply overturned the verdict. And so we have a second trial. In this one, there's a doctor who is going to testify that upon a medical exam, there were no signs of rape with the white women. However, he decided and declined to testify once the trial kind of began. And there is evidence that there was witness tampering, that he was intimidated and did not testify for fear of reprisal. So for that reason, this trial is become corrupted, gets overturned. Again, the verdict is not set aside, and we go to a third trial. In the third trial, what we have is evidence of jury tampering. The third, trial results in a guilty verdict, but upon looking at it, they specifically put together a jury where there was no solicitation of African Americans or minority groups, that they deliberately constructed a jury out of whites. That's not a jury of your peers. So this one goes all the way to the Supreme Court. It goes by the name of Norris versus Alabama. This one is overturned. Okay? But again, not acquitted. What they do is they say a right to fair trial was violated when blacks were struck by the jury. You have a right to a jury of your peers, and it should be, you can't have this kind of, you can exclude people from juries for certain reasons, but not race. All right, so we go to a fourth trial. This time, African Americans are allowed in the jury pool. They're brought in for that initial wadiv, where they do the kind of initial questioning, but they basically strike all the African Americans for convenient reasons. And what you get in this case is kind of a mixed verdict. One of the defendants is sentenced to death. What's interesting is he's later paroled. As he's paroled, he breaks his parole. He flees from the state. He turns up in 1976, some 30 years later. And of all people, he's pardoned by Governor Wallace. Governor Wallace. Remember? Segregation now, segregation tomorrow, segregation forever, right? Wallace is shot. There's a would-be assassin, and it creates this kind of like religious conversion in him, where he decides all of a sudden that he, was wrong in a lot of things in terms of his racial policy, and it explains, in part the pardon. It's amazing. Another defendant, Powell, breaks loose at one point, and he stabs a deputy. He's shot in the head. Somehow survives, but he's got brain damage, and for that reason they drop the charges of rape and they give him 20 years, right? The other defendants, they drop charges on, or several of the other defendants. The remaining ones, two of them are sentenced to 75 years, but are subsequently paroled. And again, there's this escape during parole, and one of the guys that escapes turns up in Michigan, just to show you how contentious this case was. Michigan refuses to extradite him back to Alabama, right? It's Shakespearean. None of this is going to be on the AP test, but I just think it's this amazing study of the courts proceeding with the deliberate nature of a lynch mob. They wanted a conviction, and what got lost in it is how guilty or innocent the boys were, because everything they did to get the conviction clouded that question and obscured the answer, So, as, ridiculous as it seems with the Tsarnaev trial versus the, because of the overwhelming evidence, they're going to get it right that way, all right? So, from here we go to Poclo versus Connecticut. Now, the significance of this case is this is where incorporation ends. This is where they decide, no, the Bill of Rights, in this case, the Fifth Amendment, does not apply to the states. What I have here is a case of an individual, his name is Frank Poclo, who has shot, or is accused of shooting, two Connecticut police officers. They put him up on charges of first-degree murder, but you often bring up multiple charges. It allows prosecution to have multiple pathways to get a conviction, and there's, different facets of a crime. So, there's first-degree murder as one of the charges, but as is second-degree murder. And what the jury does is return a verdict of guilty, but on the second-degree murder charges. And for the, Connecticut district attorney, that doesn't sit. There's two police officers that are dead. I think these two individuals are the ones that did it. I can't let them get away with second-degree murder. I'm going to retry them. Okay, now what is this a clear evidence of? This, again, I only get so many bites at the apple. I can't decide that I'm going to come at you until I get the verdict I want. Can you imagine? You get your day in court, the jury kind of rules. If they rule innocent, it doesn't mean the state can come at you again and again and again until they get the verdict they want, right? So this seems like a clear case of a violation of double jeopardy. Once again, we've got to first look at, does that Fifth Amendment guarantee against double jeopardy apply to the states via the 14th Amendment? And if so, was this a violation of double jeopardy? Okay, so in this case, the Supreme Court upheld the second conviction, because there's a second trial, and they convict him of first-degree murder. They uphold the second conviction, but they choose not to bind the states to the Fifth Amendment guarantee against double jeopardy. Their logic? Some rights are fundamental, some are not as critical, and I guess double jeopardy isn't at this point. Some of the Bill of Rights, such as freedom of thought and speech, are fundamental, and that the 14th Amendment's Due Process Clause absorbed these fundamental rights and applied them to the states. They agree to that. Protections against double jeopardy, however, is not a fundamental right. Why? because it's the court at that point. Again, if you're looking for a bright line of justice, it's somewhat subjective, and it depends on the court. So the court at this point decides, no, the Bill of Rights doesn't apply to the states. We arrive at a selective incorporation position, and consequently, that's where we kind of remain today. However, feel comfortable in knowing that Benton versus Maryland later on will apply the right of double jeopardy to the states.
I don't know why do the states think they have if this is all in the Constitution?
Yeah.
Why do they think the Bill of
Because
Rights
you got to go back to dual federalism. You got to go back to the idea of them seeing themselves as separate and autonomous. And the federal, it makes perfect sense to you because you've grown up in an age where, of course, the federal government has oversight over all things. But that's not necessarily the case. There's, it is a fight, throughout history for the federal government to kind of grab more power and the states to push back, and that includes within the court systems.
But what would some of these amendments apply to the states?
So a federal trial, like if you kill 2 FBI agents, and I got a conviction of guilty but only on second-degree murder, I couldn't prosecute you a second time on that federal level. That would violate double jeopardy. A state?
So what about property? So who would you're saying say?
So if the federal government seized it, they'd have to compensate you for it. If the state did, yeah, it's hard to get your head around because it seems so intuitive that of course these guarantees apply universally, but they looked at it as that's a document that guarantees federal rights. We have our own state constitution that guarantees state rights, and these two types of citizenship are different. You have different rights when you come in this building. Maybe this is a good way to think about it. Do you have complete speech? No. Do you have right to privacy in your locker? No. You have a different definition of speech because of your school citizenship. The needs to kind of protect everybody in a public school supersedes your individual rights. So that may be a way to kind of envision it. You have a different kind of definition of rights in this building than you do outside. That's how people looked at it back then. And it takes a while for that to kind of break loose. If you want to see which ones apply today and which ones don't, it's on the chart. And we'll look at that maybe to start up tomorrow when we have more time. What I want to set up real quickly is that next big chunk we're going to do. Because we're going to, again, do it in big chunks. So what we look at next is freedom of religion cases. Then we'll do speech, and we'll do press, and we'll do, due process rights. It kind of goes chunk by chunk. To understand, I think it gets a little easier now because we're no longer having to do 2 steps. We're not having to look at first, does the 14th Amendment make the Bill of Rights apply to the states? And was there a violation of the particular right in question? What we're looking at right now is just balance. In all of these cases, rights have limits. And what we have to see is, where the right ends because it begins to overlap against some other interest, right? What makes freedom of religion cases difficult is you have 2 contrasting ideas in the First Amendment. When you look at the amendment, it says Congress shall make no law respecting the establishment of religion. They can't do anything that promotes and favors a particular religion, nor can they prohibit the free exercise. Now, initially, that doesn't seem like contradictory. You can't promote a religion, and you can't inhibit a religion. I just have to be kind of religiously neutral, right? All right, let me give you a bizarre and don't think this is a real scenario, but let's say a church is on fire. You're going to put it out using governmental services. The town will send fire trucks to go put it out. If I put it out, am I establishing? Am I helping that religion am I using governmental funds and services to help and promote a religion by putting out a fire? Yeah. If I don't, am I prohibiting the free exercise? So using that scenario, you're going to understand that there are moments where damned if I do, damned if I don't. That whatever I do is going to have the effect of either indirectly promoting or indirectly inhibiting. A more realistic example is tax exemption. Religions do charitable work, and for that reason, they are considered tax exempt. Plus, the power to tax is the power to destroy. So my taxation policies, If I don't tax a religion, am I helping to establish? If I do, am I prohibiting the free exercise? Damned if I do, damned if I don't, right? If I tax, I can be seen as using that power to tax to destroy and hurt their ability to do charitable work. But if I don't, then I might be seen as favoring a particular religion. What we're going to see is that if push comes to shove, what do you think is the greater evil? Yeah. I mean, again, the nation is founded on a limited definition of freedom of religion. And therefore, we would far rather err in the side of promoting than we would inhibiting. Right? What we got to figure out, and that's in the next series of cases, is what does it mean to walk that line? So what we're going to see is cases where there's a Bible reading in school or a prayer over the intercom, and is that establishing? Okay? All right, chip away at those study guides. Do the mnemonics up to where we're at.